And welcome back again. Yours truly, Judge McAfee. Of course not. This is Judge McAfee. I am Anthony Parker Alexander of Keeping It Honest. What we try to do is we try to give the left side, we try to give the right side. And at the end of the day, we hopefully let you decide because we've given you enough information that hopefully you can find the truth in between. Black and white, bam. You have any questions or comments? You can email yours truly, Anthony Parker Alexander at parkerman2011 at gmail.com. Again, parkerman at 2011 at gmail.com. And if you have any questions or comments, you can also contact me, leave a voicemail. That number is 216-702-3718, 216-702-3718. We thank you for supporting us. Continue to support us. You get on our page and you go down a little bit to find out more information. You can click onto our Substack. That's where we write articles. And then you can also go to our Patreon page and our Cash App. And on those two pages, Patreon and Cash App, you get on there and you can contribute to our show, kind of like PBS. When you see shows on PBS and you say, wow, I like them and it's fundraising time, you give to keep those shows on. As you continue to see some of the shows that we do, hopefully you will say, boy, he puts a lot of work into those shows. And we're going to contribute to the shows. We want to be part of the family because we welcome you into our family. Speaking of families, I know everybody's been keeping up with this website as a family and what we've been doing. We have right here the trial of the Fani Willis and Donald Trump trial. And this is basically to see, well, you know what? Did Fani Willis do things that were inappropriate and should she be tossed off the trial? What we have here is the documents, and we have the result of Judge McAfee deciding, well, you know what? Fani is conflict of interest. She should be put off on this trial. So what we're going to do, we're going to talk about this real quick. If you believe that this judge is only in his 30s, wow. I'm surprised. Okay. He also has a little background real quick. Depending on how he writes this up and rules on it, he has an election coming up. Okay. And if people don't like what he did, they'll rule him out. If they like what he did, they'll keep him in. So when you're in that position, like whatever you write, some people may like or may not like. How do you write the ruling? Well, we're going to go to that right now, and we're going to show you what that ruling was all about. Because really, like I said, this can either help him or it can hurt him. But I think you guys know already what the ruling was about. So it's either, do I tell you now or do I read it? Well, you know what? I think we're going to read it. We're going to see what this is all about because it's a very interesting ruling. And the stuff that you know about it or don't know about it, I'll clue you in. So here we go. In the Superior Court of Fulton County, State of Georgia versus Donald Trump, Rudolph William Louis Giuliani, Mark Randall Meadows, Jeffrey Fazit Clark, Robert David Cheeley, Michael A. Roman. Now, he's the guy that really started this off, that started the investigation, that said, hey, you know what? Fani was up to something. David James Schaefer, Harrison William Prescott Floyd, and Kathleen Austin Latham. And Rudolph William Louis Giuliani. What a long, interesting name. But remember, he used to be mayor of New York. And He could have been president of the United States around that time after 9/11, but he kind of went some crazy ways. And now he's in this multi-universe crazy world. So here it goes. Order on defendant's missions, order on defendant's motions to dismiss and disqualify the Fulton County District Attorney. So are they going to get disqualified? Let's see. Backstory. On January 8th, 2024, defendant Roman filed a motion to dismiss the indictment and disqualify the Fulton County District Attorney's Office. 8 co-defendants later joined and supplemented the motion, raising additional grounds for disqualification. Among other allegations of disqualifying conduct, the defendants contend that the district attorney obtained a personal stake in the prosecution of this case by financially benefiting from her romantic relationship with Special Assistant District Attorney, SADA, Nathan Wade, whom she possibly or personally hired to lead the state's prosecution team. And some kind of way, Roman found out that Nathan Wade was on the case and that Fani was on the case, and that in between this, they had a romantic relationship. And so he said that they should be off the case. More specifically, defendant Roman alleges that the district attorney and SDA Wade traveled together on multiple vacations, with Wade covering many of the associated expenses. Defendant Roman later supplemented his motion with receipts from some of these travels. How did he get this? The question. The state responded with an affidavit arguing that the district attorney had not received any financial benefits through her relationship with Wade, and that their personal travel expenses were roughly divided equally. So they went on personal trips and they went Dutch. As alleged, the claims presented a possible financial conflict of interest for the district attorney. More importantly, the defense motions and the state's response created a conflict in the evidence that could only be resolved through an evidentiary hearing. Now, that's what we saw when we saw Fani and Wade on the stand, and one that could not simply be ignored without endangering a criminally accused constitutional right to procedure due to process. After receiving 2.5 days of testimony, remember that was big too. It was Fani, it was Wade, and it was like all the other cast of characters, during which the defendants were provided an opportunity to subpoena and introduce whatever relevant and material evidence they could muster. The court finds that the defendants failed to meet their burden of proving that the district attorney acquired an actual conflict of interest, in this case, through a personal relationship and recurring travels with her lead prosecutor. The other alleged grounds for disqualification, including forensic misconduct, are also denied. This also means the phone, the text, anything that they were trying to prove, the prosecutors, that supposedly right here they couldn't prove it. But we all saw it. Did it prove it to us that there was some conflict of interest? The other alleged grounds for disqualification, including forensic misconduct, are also denied. However, the established record now highlights a significant appearance of impropriety that inflicts the current structure of the prosecution team. An appearance that must be removed through the state's selection of one of two options. So the judge is giving them one or two options to get this right. The defendant's motions are therefore granted in part. Actual conflict of interest. And I remember they said in Georgia, you have to prove an actual conflict of interest. In other states, you have to prove an assumed conflict of interest or an actual conflict of interest. So if you're in another state, all you had to prove was assumed. Here, you have to prove actual. So which one did they prove? Actual conflict of interest. Our highest courts consistently remind us that prosecutors are held to a unique and exacting professional standard in light of their public responsibility and their power. How many people really live up to that? Every newly minted prosecutor should be instilled with the notion that she, also should be he or they, seeks justice over convictions, and that she may strike hard blows but never foul ones. Just be legit. Most importantly, prosecutors are expected to assume a role beyond a mere advocate for one side and must make decisions in the public's interest, not their own personal or political interest. We can go to so many cases where judges, politicians are usually doing things for themselves. And then you have certain laws to go to. His is a public duty. He represents the entire public. Recognizing these are not empty slogans nor toothless admonitions without practical effect. Georgia courts have not hesitated to step in and use their inherent authority to disqualify a state prosecutor when required, especially when a prosecutor labors under an actual conflict of interest. So they're saying that they'll get you if they need to get you, but did they get her? Disqualification of a prosecutor due to a conflict of interest is thus not a creature of stature, so much as it is a judicial remedy recognized by our appellate courts since their formation, generally on grounds of public policy. So they're going by the rules. What they're saying that if you have a conflict of interest, we can take you out. But are they? The administration of the law, and especially that of the criminal law, should, like Caesar's wife, be above suspicion and should be free from all temptation, bias, or prejudice. Easy to say. The Georgia Supreme Court has most recently denoted conflicts of interest and forensic misconduct as the two generally recognized grounds for disqualification. A conflict of interest includes acquiring a personal interest or stake in the defendant's conviction. So did Ms. Willis have a conflict of interest, a stake in convicting Donald Trump? Well, she did say when she was going to office that she was going after Trump. And she did say when she got his case that she was going to get Trump. And when she was at the church, she did mention a little bit about that too in her church speech. In such circumstances, no showing of prejudice by a defendant is required. This is so because the prosecutor's duty in the public creates an additional public interest that must remain unconflicted in every criminal case. A determination of whether a prosecutor is laboring under a conflict of interest is a fact-driven one. So were there facts in this case as far as taking Fani off or keeping her on? In this case, Wade's manner of payment is not actionable on its own. And remember, he doesn't have any receipts. Whenever a private attorney, like Wade, is paid by the billable hour, a motive exists to extend or prolong the assignment. That means you want to keep it going on so you can keep making money. This, however, is a tension that the legal profession has long accepted. It is also a type of superlative status violation that our courts have regularly denied as insufficient grounds for disqualification absent solid proof of some other conflict. And the courts have said, we don't do that. We don't try to extend billable hours. Thus, a SDA's oath of office, in combination with the supervision theoretically provided by a neutral and detached district attorney, should generally be sufficient to dispel the appearance of that improper incentive, meaning that the DA agrees with, we're not going to extend this just for billable hours. Nor would a romantic relationship between prosecutors standing alone typically implicate disqualification, assuming neither prosecutor had the ability to pay the other as long as the relationship persisted. So they're saying if you're in a relationship, as long as you're not paying for each other, that seems okay. But in combination, as is alleged here by the defendants, a prima facie argument arises of financial enrichment and improper motivations, which inevitably and unsurprisingly invites a motion such as this. So basically, no dating while you're working. As to the financial allegations, the court makes the following factual findings. On November 1st, 2021, the district attorney hired Nathan Wade to serve as an SADA and lead the investigation that produced the indictment in this case. The district attorney considered at least one other option before hiring Wade, extending an offer to former Governor Roy Barnes, who declined. So did Wade only offer that to Roy Barnes? And when he declined, did she say, hey, you know what? I've got a guy. Doesn't have a lot of experience, but I work with him. He's good. Or could she put it out there to, get people to try to apply for that position? And she went outsourced. But what if she came insourced and got somebody in her own office? Maybe she got Wade because he was the closest and he works good with her, or maybe she got Wade because he didn't really have much money, supposedly. So the contract allowed a $250 hourly rate, a relatively low amount by Metro Atlanta standards for an attorney with Wade's years of experience, and contained a ceiling on the maximum number of hours permitted. And I remember she had said at the church speak that they all were getting the same amount of money, all the other attorneys. But here in his ruling, the judge says that he was getting a relatively low amount, but then other people say he was getting a higher amount. Under the terms of the first contract, Wade was not to perform more than 60 hours of work per month without written permission. No evidence introduced indicated that Wade ever received a permission to exceed these monthly hourly caps. His contract was renewed on November 15, 2022, and again on June 12, 2023. So that means if he had to go over the 60 hours, then he would have to ask Fani to do more extended hours. And they're saying there was no record that he did. So between October 2022 and May 2023, the district attorney and Wade traveled together on 4 occasions that resulted in documentable expenses. The first included an extended trip to October 2022 to Miami and Aruba and a cruise. And that's nice. Were they going for business or were this a pleasure thing? Wade initially covered expenses for the October 2020 trip, totaling $5,223. In December 2022, the two flew to Miami for another cruise, for which the district attorney paid $1,394 for plane tickets, while Wade purchased passage for the cruise, along with other vacation-related expenses totaling approximately $3,684. This guy is doing some really research, or maybe they are. In March 2023, the two traveled to Belize, where Wade covered resort and restaurant expenses in the amount of approximately $1,000. So that's not bad, but did Fani, what kind of money did she put in? In May 2023, they traveled to Napa Valley, where Wade covered airfare, lodging, and Uber rides in the amount of around $2,829. That doesn't seem too bad as far as money. So when he's covering these costs, is he doing half? Or is that total? Meaning no Dutch. In addition, the two described taking a number of day-long road trips to Tennessee, Alabama, South Carolina, North Carolina, and other parts of Georgia. They also admitted to dining out on multiple occasions and taking turns covering the bill. With seemingly full access to Wade's primary credit card statements, so they did have the credit card statements, the defendants did not produce evidence of any further documented expenses or gifts, nor were any revealed through the testimony. In total, defendants point to an aggregate documented benefit of, at most, approximately $12,000 to $15,000 in the district attorney's favor. So they spent about that much, okay? Between $12,000 to $15,000 in the district attorney's favor. I'm glad the judge wrote this. Maybe he isn't, we'll find out. The district attorney and Wade testified that these expenditures were not meant as gifts and not designed to benefit the district attorney. Because if I'm right, anything over $100 is deemed a gift. And again, I am not an attorney. I'm just reading this. So if you're an attorney, I'll let you take the brunt of this and let me know if I'm reading this the correct way. Both testified that the district attorney regularly reimbursed Wade in cash. So she usually gave him cash. If you remember, she had thousands of dollars in her house and she carried thousands of dollars with her. And if not reimbursed, the district attorney covered a comparable related expense. For example, the district attorney testified that she reimbursed Wade in cash for the Aruba trip, which she estimated cost around $2,000, and that she gave him money for both cruises. So she just happens to have $2,000 in her pocket, or more than that, because if she gives them $2,000, she still has to have some change for food. She further claimed that she reimbursed Wade for the entirety of the Belize trip and that she paid for the Napa Valley excursions. Finally, while Wade could have bought meals in 2020, which totaled more than $100, she would also regularly pay for his meals. Okay, so sometimes she would pay for his meals, but then who keeps receipts? That's one thing I do. I keep receipts of pretty much everything that I do. And I'm curious how many people do that. So such a reimbursement practice may be unusual. How many people go Dutch with people that they're dating? All the time. And the lack of any documentary collaborations understandably concerning. So they had no receipts. They say they do this, but they have no receipts. Yet the testimony withstood direct contradiction, was corroborated by other evidence. For example, her payment of airfare for two on a 2020 Miami trip, and was not so incredible as to be inherently unbelievable. We all saw the same thing, and we all thought a lot of ways it was unbelievable. They went to Dutch literally in everything, and she carried money literally everywhere, as much as to cover $2,000 trips. However, as the district attorney herself alleged, no ledger exists. Other than a best guesstimate, there is no way to be certain that expenses were split completely evenly, and the district attorney may well have received the net benefit of several $100s. So if you think about this, if you're a couple, can you go back over the past years and think about how you dated if one person paid for another, and if the money that way was used or paid, did he use any of that to go out? And if he did, isn't that his money because he got paid? So despite this, after considering all the surrounding circumstances, the court finds that the evidence did not establish the district attorney's receipt of material financial benefit as a result of her desire to hire and engage in a romantic relationship with Wade. Simply put, the defendants have not presented sufficient evidence indicating that the expenses were not roughly divided evenly, or that the district attorney was, or currently remains, greatly and primarily interested in this prosecution. And if you remember, are they still dating? She said they weren't. He said they weren't. But then some people are saying they still are. So really, if I sit back and, because this is what has people, thinking about this. I get paid to work on CNN, to do an investigative story. And I'm like, wow, this is great. This is like really, my investigation is how mainstream media is pretty corrupt at times in telling stories, how they don't put everything out there. And so I'm being paid by the government to do an investigative story and work with CNN. But they say, Anthony, it's a lot of work. We also want you to get an assistant. And I'm like, I know this one guy, Chris Cuomo, who I'm going to see about assigning this case with me. And I asked Chris, and he says, Anthony, I can't do it. And I'm like, wow. So my girlfriend, who is a reputable broadcaster, but she got laid off at her TV station. I say to her, hey, Vanessa, I've got this opportunity that will help you out. I need somebody good. I need a assistant to help me cover the story about mainstream media and how corrupt they are. Are you interested? And she's not making a lot of money now. And she says, wow, thank you. But this case is so big, she doesn't have that experience for that. But I know how good she is, so I'm going to hire her. And so I hire her, and she's helping out with the stories, and I technically pay her. I pay her $2,000 a week, and she gets paid. And at the end of the week, she says, "Hey, you know what? I've got money now. I'm getting paid. Let's go on a trip. Let's go to Canada." And I'm like, "Okay, all right. Well, thank you." She never took me out before, really. Now she's making big money, 2,000 a week. It's not really a lot, but 2,000 a week. And so we go to Canada and everything, and she pays my way. And I'm like, "Wow, thank you. That's so nice." And then we go to dinner, and she wants to pay my dinner. I said, "Let's go Dutch." And do we keep the receipts? Do we keep the receipts from going to Canada and going Dutch? I mean, we might, but it's no big deal. So now, if you look at that, is that a conflict of interest? So I've got this job. I'm paying her to help me out. With the money that she's helped me out, she takes me out to dinner. So are these kickbacks? And are we in a romantic relationship? Yes. Is she hired to work for me? Yes. Is it a conflict? I don't think so. So what do you think? And I tried to put it in layman's terms. So in addition, and much more important, the court finds, based loosely on the district attorney's testimony, that the evidence demonstrated that the financial gain flowing from her relationship with Wade was not a motivating factor on the part of the district attorney to indict and prosecute this case, meaning it wasn't all about money. While a general motive for more income can never be disregarded entirely, the district attorney was not financially destitute throughout this time or in any great need, as she testified that her salary exceeds $200,000 per year without any indication of excessive expenses or debts. So she's making $200,000 a year. Why would she need any more money? That's what she's saying. Similarly, the court further finds that the defendants have failed to demonstrate that the district attorney's conduct has impacted or influenced the case to the defendant's detriment. Willis prejudice is not a required element for disqualification. It is relevant to consideration of due process and the defendant's requested remedy of complete dismissal. So they keep going back and forth. She's making a lot of money. She has no bias in this. And as I just gave my example, is this prejudice? We are analyzing the case, Fani Willis versus Donald Trump, and we're going to the judge's ruling. You're watching Keeping It Honest with yours truly, Anthony Parker. If you have any comments or questions, you can email yours truly. It's parkerman2011@gmail.com, parkerman2011@gmail.com. And you can text me, 216-702-3718, 216-702-3718. And we are going through this document. Defendants argue that the financial arrangement created an incentive to prolong the case, but in fact, there is no indication the district attorney is interested in delaying anything. Indeed, the record is quite to the contrary. Before the relationship came to light, the state requested that the trial begin less than 6 months after indictment. So they wanted to do this quickly, supposedly. This is Fani. Prosecutors are saying no, they didn't. They wanted to delay it. Soon after, the state opposed severance of the objecting defendants who did not demand their statutory right to a speedy trial. The state argued that it only wanted to try the case once, assuming that such a trial would have been affirmed after any necessary post-conviction appeals. The state amended its proposed timeline November 2023 to request that the trial commence less than 1 year after the return of the indictment. And even before indictment, the district attorney approved a grand jury presentation that included fewer defendants than a special purpose grand jury recommended. In sum, the district attorney has not in any way acted in confirmation with the theory that she arranged a financial scheme to enrich herself or endear herself to Wade by extending the duration of prosecution or engaging in excessive litigation. So she did not want to extend this. She wanted to get this as fast as possible. This is what the judge is saying, Judge McAfee. Without sufficient evidence that the district attorney acquired a personal stake in the prosecution or that her financial arrangements had any impact on the case, the defendant's claims of an actual conflict must be denied. Boom. So it's denied right there. This finding is by no means an indication that the court condones this tremendous lapse in judgment or the unprofessional manner of the district attorney testimony during the evidentiary hearing. If you remember when Fanny got up there, it was Fanny law. Okay. Fanny law. We won't forget that. Some people say she was strong, some people say she was overdoing it. Rather, it is the undersigned's opinion that Georgia law does not permit the finding of an actual conflict for simply making bad choices, even repeatedly. And it is a trial court's duty to confine itself to the relevant issues and applicable law properly brought before it. So even though she might have made some bad choices, or some other people who understand, they can't dismiss that and say she's off the case. Embarrassing, but then of course she did say some things, which of course she's going to deal with down the road, which you'll find out. Other forms or sources of authority, such as the General Assembly, the Georgia State Ethics Commission, the State Bar of Georgia, the Fulton County Board of Commissioners, or the voters of Fulton County may offer feedback on any unanswered questions that linger. But those are not the issues determinative to the defendant's motions alleging an actual conflict. So what this judge has said, and this is dealing with Fannie and Wade and anybody else that's an attorney. Okay, well, you may get away with this. I may let you get away with this. But going down the road, for some of the things you said on the stand, you're still going to have to sit in front of the General Assembly, the Georgia State Ethics Commission, the State Bar of Georgia, the Fulton County Bar of Commissioners, and even the voters of Fulton County. And that is something interesting that Judge McAfee, who's up for term, and also Ms. Willis, who's up for term, will have to deal with. It's all about politics. So the appearance of impropriety. The appearance of impropriety here we go. That's my dramatic pause. Finding insufficient evidence of an actual conflict of interest does not end the inquiry. Our appellate courts have endorsed the application of an appearance of impropriety standards to state prosecutors, even without any explicit finding of an actual conflict. A district attorney may not be compensated by means of a fee arrangement which guarantees at least the appearance of a conflict of interest. So of course, you can't have a conflict of interest where it even appears that you're getting paid to do an opinion. A prosecutor's close personal relationship with the victim in a case may create at least the appearance of a prosecution unfairly based on private interest rather than one properly based on vindication of public interest. Wait, Fanny, does it seem like that in that verse? In that case, the individual prosecutor who has the conflict may be disqualified. Did Fanny have a conflict? Should she be disqualified? The cases cited here, which they cited, that resulted in disqualification did not hold that an actual conflict is a necessary prerequisite. The state nevertheless argues that the facts presented suggest as much, and while that may be so in some instances, the opinions do not make that finding, and this court cannot ignore the explicit language of the Georgia Supreme Court and multiple opinions from the Georgia Court of Appeals. Further, while Davenport and that's the case is the first instance this court can find where the exact phrase appearance of impropriety is used to assess disqualification of a state prosecutor. The reference to Caesar's wife, and remember he said that earlier, and the admonition against all temptation and suspicion demonstrate the principle has long been endorsed in Georgia law. So they are talking really about previous cases, and he's comparing some cases against this present case, and it being a conflict of interest. So from here right now, is he saying that He's in favor of dismissing this case. We're keeping Fani on this case. So it says, it continues, while formally undefined in Georgia precedents, an appearance of impropriety is generally considered conduct or status that would lead a reasonable person to think that the actor is behaving or will be inclined to behave inappropriately or wrongfully. And they say actor. And so are they saying that, we're going to get her off the case anyway because it's looking like there's conflict, or it is, and we're stopping it right now? So borrowing from federal judicial recusal standards, a reasonable person is not an uninformed member of the public with only a passing knowledge of the facts at hand. The appearance standard recognizes that even when no actual conflict exists, a perceived conflict in the reasonable eyes of the public threatens confidence in the legal system itself. And isn't that true, kind of what we really don't know, but it looks like this conflict of interest? When this danger goes uncorrected, it undermines the legitimacy and moral force of our already weakest branch of government. So why do they say that's the weakest branch of government? And this is the judge saying this. And when you have the judge saying this is the weakest form of government, what does that say to the laymen that have to sit in front of the weakest form of government? That's pretty bad. Thus, it is that sometimes an attorney, guiltless in any actual sense, nevertheless is required to stand aside for the sake of public confidence in the probability of the administration of justice. Excuse me. This court finds that it can, and indeed must, consider the appearance of impropriety as a basis for a state prosecutor's disqualification, especially in recognition of the critical role that the prosecutor plays in the criminal justice system. One final observation can be gleaned from a careful study of our appellate decisions applying this standard. The remedy can vary. Unlike an actual conflict, the finding of an appearance of impropriety does not automatically demand disqualification. Our Supreme Court has previously analyzed disqualification under an appearance standard in a civil case using a continuum, recognizing that disqualification is not always the appropriate outcome. So he is saying that sometimes disqualifying isn't the perfect thing to do or isn't the right thing to do. So in this case, it's almost like he did half and half. I'm going to disqualify, but I'm not going to disqualify. That way I will appease both people and appease really both acts of the law. So at the end of the scale where disqualification is always justified and indeed mandated, even when balanced against the client's right to an attorney of choice, is the appearance of impropriety coupled with a conflict of interest or jeopardy to a client's confidence. In these instances, it is clear that the disqualification is necessary for the protection of the client. Again, it is clear that the disqualification is necessary for the protection of the client. Somewhere in the middle of the continuum is the appearance of impropriety based on conflict on the part of the attorney. As discussed above, this generally has been found insufficient to outweigh the client's interest in counsel of choice. This is probably so because, insufficient to outweigh the client's interest to counsel of choice. Sorry about that. This is probably so because absent danger to the client, the nebulous interest of the public at large is the property of the bar is not weighty enough to justify disqualification. Says a lot. Finally, at the opposite end of the continuum is the appearance of impropriety based not on conduct but on status alone. This is an insufficient ground for disqualification. And he keeps saying the same thing. The Supreme Court further noted that disqualification due to an appearance of impropriety should rarely occur when there is no danger that the actual trial of the case will be tainted. So when it seems like the case isn't being, misconstrued, that there shouldn't be any appearance of disqualification. Wow. When there is no claim that the trial be tainted, appearance of impropriety is simply too slender a reed on which to rest a disqualification order, except in the rare cases. All right, I'm just going to different things. Moreover, to ensure that no conflict of interest or the appearance of one might develop, the district attorney took the prudent step of ordering the investigator to take no part in the investigation or prosecution of the case. And so they're talking about other different cases. Nor would the finding of an appearance of impropriety on the part of the DA herself, in contrast to an actual conflict, necessarily result in a disqualification of the entire Fulton County District Attorney's Office. So if she should be disqualified, besides her, should the whole office be disqualified? This judge is saying no. Some people are saying, well, you know what, she's the head of the DA. And if you're getting the head, you might as well get the body. When the appearance of a conflict exists, only the affected prosecutor, be they elected or appointed, is affected. So they're saying just her, not anybody else. The individual prosecutor who has a conflict based on at least the appearance of impropriety may be disqualified from participation in the case, but not all the prosecutors who work with him. Again, they're saying it again. If you're going after somebody, go after her. With these principles in mind, the court finds that the record made at the evidentiary hearing established that the DA's prosecution is encumbered by an appearance of impropriety. This appearance is not only created by mere status alone, but comes because of specific conflict and impacts more than a mere nebulous public interest because it concerns a public prosecutor. Here's an example. Even if a romantic relationship began after Wade's initial contract in November 2021, the DA chose to continue supervising and paying Wade while maintaining such a relationship. So this judge is saying that this relationship continued even after she hired him. She further allowed the regular and loose exchange of money. Regular and loose exchange of money. That sounds like, something from the streets. Loose and exchange because they didn't have any receipts. You say it again. She further allowed the regular and loose exchange of money between them without any exact or verifiable measure of reconciliation. Wow. This lack of confirmed financial split creates a possibility and appearance that the district attorney benefited, albeit non-materially, from a contract whose award lay solely within her purview and policy or policing. So isn't it showing a conflict of interest? He's saying somewhere that there was money exchanged, but he seemed like he can't really prove it because there is no receipts. Interesting. Most importantly, were the case allowed to proceed unchanged, meaning if he let this continue, the primo facie concerns raised by the defendants would persist, that they would continue to do money. Wow. So he's saying that if a lot of big words. But when you get to the big words and get to the small words, what do you think of this so far? So he's throwing out the Texas. He's throwing out Bradley's Texas to Ashley. He's throwing out Bradley when he was in front of the court where he didn't say anything, but in Texas, he totally said something different. He's throwing out Wade because Wade said things that seemed untrue. He's throwing out Wade's proceedings as far as his wife's concerned. That may not have anything to do with the case because this is a different separate case. But on paper, he said he wasn't working, only had $2,000 in the bank, and didn't establish that he's got a new job when he put together the law case. He's thrown out their own personal Texas and has thrown out even the resemblance of a conflict of interest, and also the church speech, which we're going to get to. So you're watching Keeping It Honest with yours truly, Anthony Parker Alexander, and we are talking about this court case. What the option can be. So the options are they dismiss this and they take Fani and her whole background of people, the DA and her assistants, and come off the case because it's been proven and assumed that there was a conflict of interest. And they take them off because it's been proven there's been a conflict of interest. You take them off because there was assuming there was a conflict of interest. I would do it there. Or you take Wade off because he's a special prosecutor, and you keep her. Now, why? Because he has, like I said, a couple things involving him. The wife thing, the going to court thing, which to me in a way doesn't show anything connected to this case, but I said paperwork. He said that he wasn't working a new job, and the day he gave us divorce proceedings was the day that he got that new job. But his divorce proceedings were dated the day before. That's kind of shady. As far as what he does with the money, to me, that's on him. But for so many people that want them off the case, there's so much invested in this case. So if you take the DA off, they'd have to start all over again. If they start all over again, they could drop it. It could go to another city. That city could say, you know what, this is too much. We don't want to do it. And then they don't want to try this case. And to me, the best thing would be if Fani was still on the case. And and Wade was off. And then it's Fani against Trump. And for her, how she came in so strong, Hopefully she's gotten humbled through all of this, and she will do the best to try this case in the right way. So since they kind of seem like they can't figure out if there was a conflict of interest, but yet it kind of was, the best thing it would be is to get rid of Wade and keep Fanny and go from there. Let me know what you think and let me know if that was a thought that you had. So you're watching Keeping It Honest with yours truly, Anthony Parker, as we get the findings of this case. Two choices are, okay, Fanny, if you want to continue with this case, you can continue. But if you continue, you have to take Wade off. But if you want Wade on, then you and your whole department is disqualified. And wow, so those are two choices, two big choices. So it's, Fanny, if this is your boyfriend, you gotta let him go for you to continue this case. But if this is your boyfriend and you love him, and love is stronger than whatever, then you're going to stay with him, and then you get to get kicked off this case, and so does your team. So if you kick him off, do you say nothing personal and boyfriend, you lose a lot of money because I've got to keep this case because it's making a name for me? Or do you say, you know what, forget this, let me just keep our love together, but I'm going to lose this case. Remember that song, Love Will Keep Us Together? How much love will keep you guys together? And what is that Star Trek thing? The ways of the many outweigh the ways of the few. So it's interesting because it seems like Nathan Wade is the one that's standing in front of this. Um, but if you know a little character about Nathan Wade, he would probably want to look out for him, and depending how it meets him the most would be his decision. So whose decision is it? Is it Fanny to say, "Hey, I got to get rid of you," or is it Nate to say, "Hey, um, I'll do whatever you want"? So as we continue. And go ahead and watch it because it's very, very interesting. It's about a 30-minute speech. She talks about God. God put her in her place. She talks about God, talks about King. She talks about what she's going through. How God put her in her place to try this court for this case. And she gives anecdotes how hard it's been for her life and everything. And then she talks race, black man, white woman, white man. Um, and at the end of the day, it's like, wow, was this a campaign? And she did this Martin Luther King thing. You be the judge, but watch that speech and let me know what you think of the infamous church speech because it's a good speech, but it makes you think. Some of it is good to do in church, but was all of it? Do I drink it? I don't know. It's so good. You told me not to touch it. I'm gonna drink it. Wait a minute. It's not good. He told me not to touch it. It's now I can't talk. Now I really can't talk. I paid for it. He told me not to do it. So there you go. Kind of like your mom says, don't touch the stove. So if you notice when I read this, he says, look, cell phones out in line, texts out in line. I know you're not giving me all the proof, and you also said something about use your campaign money. Well, you know what? I'm not here for that. I'm just here to see if you did anything. I can see it that you have, but I can't prove it. There's the assumption that you might have, but I still can't prove it. So we're gonna have to do something because I know you guys did something. So I'm gonna let Wade. I'm gonna get rid of Wade. That's the easy one. I can't get rid of you. But for some of the things that you did, somewhere down the line, you can't get a car by me. Plus, I'm running for office, so I'm kind of gonna give you a pass. But some of the things you did legally, that bar is gonna contact you, and there's gonna be other people you may have got through me. Rest assured, you got or you thought you got through everybody else, but there's gonna be a time where you're gonna pay for it. We have so many words. Now we're closing. Thank you for staying with me. The conclusion. Whether this case ends in conviction, acquittal, or something in between, the result should be one that instills confidence in the process. Really, are we confident about this? A reasonable observer, unburdened by partisan blinders, should believe the law was impartially applied, that those accused of crimes had a fair opportunity to present their defenses, and that any verdict was based on our criminal justice system's best efforts at exerting the truth. Any distractions that distract from these goals, if remedial under the law, should be proportionally addressed. After consideration of the record established on these motions, the court finds the allegations and evidence legally insufficient to support a finding of an actual conflict of interest. However, the appearance of impropriety remains and must be handled as previously outlined before the prosecution can proceed. The defendant's motions are therefore granted in part and denied in part. So ordered. It's 15th day of March, 2024. Judge Scott McAfee, Superior Court of Fulton County, Atlanta Judicial Circuit. So let's go through this last. He has pretty much said, I'm not going to discount the whole DA, but I'm going to discount Wade. Or you want to keep Wade, I'm taking you off the whole case and closing the DA. So you think about this in your right mind, who wants to close the DA? Really, I mean, even if it wasn't her, no matter what, if you're the head of your DA and you're trying to go after somebody, especially the president, you're going to give up trying to indict the president over somebody you care about? So I think McAfee kind of knew, I'm going to put this in her hands because I don't want to deal with it. I don't want to get people upset because I am running for office. So again, whether this case ends in conviction, acquittal, or something in between, the result should be one that instills confidence in the process. So are you confident? I don't think no. I don't think you are. A reasonable observer, unburdened by partisan blinders, should believe the law was impartially applied. That's not true. That those accused of crimes had a fair opportunity to present their defenses. That's not true. And that any verdict was based on our criminal justice system's best efforts to asserting the truth. So does that mean that everybody got on the stand, got on there for nothing? Man, think of Bradley and what he did. The Texas, the lying, the sweating. What about her ex-girlfriend? Did she get up there for anything? Did she waste her time? Any distractions that distract from these goals, if remedial under the law, should be proportionally addressed. Distractions, even the cell phone numbers, all that time. After consideration of the record established on these motions, the court finds the allegations and evidence legally insufficient to support a finding of an actual conflict of interest. So even if it was an actual, was it a assumption of a conflict of interest? However, the appearance of impropriety remains. So if it appeared, then why don't you just close it? It must be handled as previously outlined before the prosecution can proceed. The defendant's motions are therefore granted in part and denied. Wow, in part. So the end game for this was what exactly? Was it McAfee? Said, man, I've got to find an in-between because people are going to be upset. If I throw them off the case, and this is an African-American district, I don't think I'm going to get the African-American vote. And I'll lose because I'm going up against an African-American challenger. That's one. But if I get rid of her, I won't get the vote, like I said. And if I keep her, I might get the vote, but I'm still going up against an African-American challenger. So how's it going to help me in the end? If I get rid of her, I have a chance to not win. If I keep her, I have a chance to win. But that African American challenger, because maybe nobody's satisfied with what I choose, because I get rid of Wade and I keep her, they may say, okay, well, you know what? You did what you did. We're going to go with this other guy. I don't know if this is a race, dealing with race for me. So, darned if you do, darned if I don't. Do I keep this going on? And I'm going to have people still upset with me? In the long run, I have to look after me. Do I play policy games? I'm going to have to. But in the long run, myself, I think there was appearance because I have put some things in my ruling, the church speech, the book, the cell phones can't prove, the people saying that, yeah, we know you're together, but really can't prove it concrete. So I get rid of him, meaning Wade, and it continues. But I'm still going to be the judge, no pun intended. And we'll still see how this goes on. So he's putting a catch-22, but he still survives for another day. As far as Fani, she had a tough choice. Of course, she's not going to give up because she knows she's up for re-election. And she also wants to go after this. And I noticed there's more African American women I've noticed from watching streaming shows who are for her than against her. But then again, if she's done things, maybe, and wasn't able to prove it, maybe she will. Well, Chris, look at this. But what did she win? She won the right to continue this fight, to see how really good she is. But it's interesting because I think I didn't like when they wanted to use cell phone records in Texas. She said they should not use it because the percentage of it being good is not good in court. But it's funny because she's in the middle of a trial right now that the same company that was used against her to say the cell phone records in Texas were where she was at and where Wade was at and everything, she said it should not even count in court. But the same company that was used against her is also being used in a trial that she's trying now. So then wouldn't that be other cases where that she's trying where they use these phone records? Now they're going to say we should have a retrial because that company that you said wasn't good when you're dealing with us to try to put us in jail, that is good. That's inconsistent. So what are some of those court cases, some of the drug dealers, some of the other people where they were found guilty because of these phone records, and specifically because of the phone records. When they're using the same company with the phone records against you, you say that they're invalid. So are all those cases that Fani tried going to be reopened? Excuse me. I'm all choked up thinking about it. But rest assured, Trump and Roman and all of his people are going to find loopholes in this. And they're going to kind of try to keep this case involving her muddled. And it's interesting because while Donald Trump's running for president, he's got all these cases. While she's going after Trump, she's going to have a bunch of cases after her too. Possible disbarment, possible sanction. So you be the judge. These two people going head to head. It's going to be interesting. It's going to be, I think, exciting. This is not the end of Fani Willis. This may just be the beginning. So I myself, and we like seeing, things happen. How many times people go to, different events because they want to see things happen. Okay, how many people watch news? They're not going to watch it because of good news. They're watching it because it's bad news. That's what's keeping people watching it. But you have Fani and you have Donald Trump, and you just had our ruling, and we just gave you a ruling. We kept it honest. We did it with Parker Smith. We hope you liked it. There's a lot of players. There's still the ones that are there. They're not going anywhere either because people are still going to do shows on them. Um, this has been exciting to yours truly. And I'll give you my background too. I was my own attorney. I was a pro se. I was an attorney, and a pro se is your own attorney. I represented myself. I was a single dad that raised my kids. I had um, become a pro se, my own attorney, and I won and got total custody of my kids. So the law has always been fascinating for me. I was a guardian ad litem. And so I know a little bit about the law, not like these lawyers, but I did this because I wanted the normal person to know a little bit how these are and explain it kind of as a normal person, but um, to see what happens when you see that, and hopefully you learn something as me and you both learned something. So the law is the law, but is the law the law? And I can tell you politically, I can tell you through the law, if it's not benefiting you, then they're gonna sway the law a different way. And you just pray that the scales are balanced, but sometimes they're not. Because as you know, there are a lot of people out there that have skirted the law. And if it was me and you, they would go after us. So this Fani Willis Donald Trump case is a prime example. Which one's going to give up the most? Which one is more likely to drop? Donald Trump legally or Fani Willis legally too? It's fascinating. So hope you enjoyed it. Tell your friends. You can contact me. It's 216-702-3718, 216-702-3718. You can contact me, leave me a message, text me. And if you'd like to email me, that email address is parkerman2011@gmail.com, parkerman2011@gmail.com. And hit the like, subscribe button, tell your friends. And we thank you for watching our show. I am Anthony Parker Alexander. This is Keeping It Honest. Keep your head up. Always believe in yourself, and therein will lie your answer. God bless. Keep it honest.